At trial, when an attorney asks a compound question, why is it so important for me to jump up out of my seat and yell out, "Objection, Judge! That's an improper question"? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now you've gone to trial. It's been 2 long years before your case has finally come up for trial. Let's say you sued your doctor for medical malpractice. You claim that he was careless and that his carelessness was a cause of your injury. You also claim that your injury is significant and permanent. And now you've reached trial. The defense, the doctor, has claimed, hey, I did nothing wrong. And even if I did something wrong, so did you, Mr. Patient. And by the way, he says, listen, I did nothing wrong, but if I did, so did you, Mr. Patient. And by the way, if I did something wrong and you did something wrong, well, guess what? Whatever I did wrong didn't cause your injury. And then he turns around as a defense and says, hey, if I did something wrong and you also contributed, and maybe whatever I did caused your injuries really are not as bad as you claim them to be. So now they force you to go to trial. In the course of cross-examining our medical expert, the defense lawyer asks a compound question. Now, what is a compound question? It's a question that demands more than one answer, which is impossible to give. So let's say, for example, Dr. Jones, isn't it true that you reviewed the records on behalf of Mr. Oginski's law firm and that you were paid $5,000? That calls for 2 answers. Number 1, that he reviewed the records on my behalf, and number 2, that he was paid that fee. What happens if he was paid a different amount? How do you answer that question? The problem is you can't answer that question yes or no. You can't answer that question I don't know or I can't answer your question. Why? When you ask a compound question, you are asking the witness to give you an answer that is factually incorrect. You're asking multiple questions all contained within one. So the proper way to do it, the better practice is, say, hey, Dr. Jones, isn't it true that Mr. Oginski asked you to review these records? Yes. Isn't it true that you're being paid a fee to review these records? Yes. And the fee that you're charging him is $5,000. Isn't that true? Yes. So what have I done? I've asked short leading questions that call for one question and one answer only. That's the right way to do it. Instead of saying, hey, Dr. Jones, isn't it true that Mr. Oginski asked you to review these cases? You reviewed them, you came to certain conclusions, and you asked for a fee to be paid $5,000. If he says yes, what is he saying yes to? Yes to all of it? Yes to the first part, the second part, the third part? The problem with a compound question is you don't know to what the answer applies to. So that if someone were reading the transcript, let's say the losing attorney appeals the case, and now the appellate court has to review the transcript, the actual transcript of the questions and answers that were given during the course of trial. They're looking to see what was asked and what was said. And now they see that a compound question was asked, and the doctor said yes. Well, is it yes to reviewing the records? Is it yes to the fee? Is it yes to reaching conclusions? What is it yes to? You don't know. So therefore, I have an obligation to stand up and make an objection. And the way to make an objection in court is by standing up and literally yelling out, Your Honor, I object. That's a compound question. And now the judge has to immediately rule to decide whether I am right or not. If I am right and my legal objection is appropriate, the judge turns to the defense lawyer and says, objection sustained. Which basically says, hey, counselor, you cannot ask that question. It's incorrect. Try it again. So now the attorney should go ahead and try and ask a different question. But there are some attorneys who are hell-bent on asking the same question over and over and over again, even though they've been told it's an improper question, even though it's an incorrect question. Why would they do that? They do that for one of 2 reasons. Either they're naive, or 2, they just don't know how to ask a different question. You know, you'll find that the best trial lawyers in New York can ask the same type of question 10, 15, 20 different ways. It's amazing. So if they get an objection about the way they asked the question once, they now try it a different way. And then they try it a different way if they get another objection, and another way. Because there's so many different ways to word a question to try and get the same information. And if an attorney is unable to do that, now you know either that they don't have experience doing this, or they are so hell-bent on asking the same question, believing that they must get an answer to their question, that this wording is so appropriate and so important to them that they have to have an answer to that phrase. Well, the reality is no. That question is legally incorrect and improper. You now have to ask a different question. Now, if the judge says, hey, Mr. Oginski, that question is fine, he will say, objection overruled. What does that mean? It means that even though I have objected to the question because I believe it's inappropriate, the judge thinks it's absolutely fine, and now the attorney can ask that question, and the witness must answer that question. So why do I share this great information with you? I share it with you because this comes up in every single trial. One attorney or another at some point asks a compound question, and you have an obligation to stand up and object to make sure that the question is worded properly so that the jury understands it, so that they know which answer applies to which part of the question, and ultimately, if needed, that an appellate court reading the transcript will know exactly the same thing. You know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.